Case Law No. 72, 2024 AL, regarding the determination of inheritance as land use rights in cases where the will does not show a specific land area. Approved by the Council of the Supreme People's Court on February 20th, 21, and 3, 2023 and promulgated together with Decision Number 119 QDCA, dated May 15, 2024 of the Chief Justice of the People's Court Supreme People. Source of the case law, Cassation Decision Number 60 2022, the DSGT, dated December 19, 2022, of the Council of Judges of the Supreme People's Court on the civil case, dispute over the inheritance of land use rights, between the plaintiff, Ms. Nguyen Thai G with defendant Mr. Nguyen Van Nhu. People with related rights and obligations include 19 people. Location of case law, paragraphs 4, 5, and 8 of Court's opinions. Case law brief. Case law context. Inheritance is land use rights determined according to a legal will. The content of the will identifies the four neighbors, but does not show the specific land area, and there is no dispute about the four neighbors. Legal solutions. In this case, the court must determine that the inheritance is the land use right determined according to the actual land area measured according to the four quadrants shown in the will. Regulations related to case law. Articles 624, 630 and 634 of the Civil Code 2015. Keywords of case law: inheritance, legal will. Inheritance according to will, determining according to four proximate. Case content. In the lawsuit dated March 15, 2017, and testimony during the case settlement process, the plaintiff, Ms. Nguyen Thai G, presented. Her father and mother are Mr. Nguyen Van M, died in 1998, and Mr. Nguyen Thai B, died in 2010. Mr. M and Mr. B have 8 children including Nguyen Thai H, Nguyen Thai M1, Nguyen Van C died without remembering the year, Nguyen Thai G, Nguyen Van K died in 2016, Nguyen Van L, Nguyen Thai P and Nguyen Van U. The inheritance left by Mr. M and Mr. B is the land with an area of 32,500 square meters on map number 10D, plots 809 and 810 in Hamlet N, Commune T, District C, now District P. CA Mau Province. The origin of the disputed land is that Mr. B's father and mother exploited it, then let Mr. M and Mr. B and his wife manage and use it. In 1993, Mr. M declared in the Cadastral Index Book of Map Sheet number 10D, plots number 809 and 810, and was granted a Certificate of Land Use Rights by the People's Committee of District C. In 1994 and 1995, Mr. Nguyen Van Nhu lived separately on land in Hamlet A, Commune T, District P, while she lived with her parents since childhood and managed and used the 32,500 square meters of land mentioned above from then until now. On May 16, 1998, Mr. M made a will leaving her 15 dunes of land for cultivation, and the remaining 10 dunes will be enjoyed by those who worship their grandparents. When making the will, Mr. M was still lucid. In 2000, Mr. U forged Mr. M's signature to make a land use right certificate, and was granted a land use right certificate in Mr. U's name by the People's Committee of District C without her knowledge. In 2004, Mr. B met the children in the family and agreed to give her the entire 32,500 square meters of land for her to manage and worship her grandparents. The minutes of the family meeting were authenticated by the People's Committee of T Commune. In 2006, Mr. B continued to make a will for her of the entire land mentioned above. After Mr. B died, she still managed and used the land until now. However, in 2016, Mr. U prevented her from using the land, claiming that this land was given to Mr. U by his father and mother. Therefore, She sued to request the court to cancel the Certificate of Land Use Rights, issued by the People's Committee of District C to Mr. Yu on November 15, 2000, and recognize her land use rights. According to the will for the portion, the land has an area of 32,500 square meters. Actual measurement is 35,180.7 square meters. The house on the land belongs to Mr. M and Mr. B. Mr. Yu was the only one who built it when he was still living with his parents. When Mr. Yu went somewhere else, she used it and repaired it. The defendant, Mr. Nguyen Van Yu, presented. He agreed on the blood relationship as presented by Mrs. G. The origin of the disputed land was discovered by Mr. M and Mr. B in 1950. In 1983, Mrs. G built a temporary house in front of the disputed land to do business, while he, the youngest son, continued to live together and take care of his parents, and directly manage and use land. Around 1993, he built a house with family money because he was living with his family at that time. In 1998, his father and mother gave him land, with a family meeting minutes, and he submitted it to the competent authority to be granted a land use rights certificate. In the same year 1998, he declared and registered according to regulations, and was granted a land use rights certificate by the People's Committee of District C on November 15, 2000. In the same year 1998, he declared and registered according to regulations, and was granted a land use rights certificate by the People's Committee of District C on November 15, 2000. After Mr. M died, because life was difficult, he went to another place to do business, while his wife and children still lived in the above-mentioned house. In 2010, Mr. B died. In order to create conditions for Mrs. G to have an income, he went to live elsewhere, leaving the house for Mrs. G to live in and cultivate the land. The land that he and his wife are currently using in Hamlet I, Commune T was purchased with money from him and his wife. As for the fact that his parents made a will and had a family meeting to give Mrs. G land, he did not know. In the counterclaim dated March 16, 2018, Mr. Yu requested the court to force Ms. G to return to him the entire area of the disputed land and the four-level house on the land. Persons with related rights and obligations present. Ms. Nguyen Thi M1 presented. Ms. G has lived with her father and mother since childhood. The fact that father and mother made a will for Mrs. G's land was witnessed by her. When Mrs. B had a family meeting, she attended, without Mr. Yu present. The house on the land was built by her father and mother, because at this time the children were still living with their father and mother. The land that Mr. Yu is currently managing and using is about 0.6 hectares in Hamlet I, Commune T. His seventh brother sold part of it to Mr. B, and his sixth brother gave him a part of the land to support his parents, but Mr. Yu did not take care of my father and mother. The disputed land and assets on the disputed land belong to Mrs. G according to the will left by her father and mother. Mr. Nguyen Van L presented. The house was built by the father, mother, and brothers in the family, not by Mr. Yu. When the father and mother were still alive, they made a will and held a family meeting to give Mrs. G the disputed land. As for the land that Mr. Yu is managing and using, there is a part he sold to Mr. Yu and a part given by the sixth brother to support his parents. He requested the court to resolve the disputed land belonging to Mrs. G according to her parents' will. Ms. Nguyen Thi P presented. When her father and mother were still alive, she heard her father give Mrs. G 5 merits of land. She did not ask to divide the inheritance, but only asked to leave 0.5 square meters of land for the grave, which no one had the right to divide. Ms. Nguyen Thi H presented. In the past, when her father and mother were still alive, they said they made a will to leave the disputed land to Mrs. G. She does not remember when they made the will because it has been a long time. Mrs. G has lived in the disputed land since she was a child and was the one who took care of her father and mother while they were still alive. After her father and mother died, Mrs. G was the one who worshipped her father and mother. Mr. U does not manage the disputed land, because Mr. U has his land. 5. Mr. Nguyen Van V presented. He requested to divide the inheritance for the part of the estate that his father, Mr. C, is entitled to. 6. Mr. Nguyen Van T. Agree with Mr. V's presentation. 7. Ms. Nguyen Thuy H. Request the court to resolve the matter according to the provisions of law. In first instance civil judgment number 04. 2019, DSST, dated April 16, 2019, the People's Court of Ca Mau Province decided, accepting the request to sue for inheritance division from Ms. Nguyen Thuy G to Mr. Nguyen Van U. Ms. G is entitled to inherit the inheritance left by Mr. Nguyen Van M and Mr. Nguyen Thuy B, including the land according to actual measurements. The area is 35,180.7 square meters located in Hamlet N, Commune T, District P, Ca Mau Province, with 4 neighbors mentioned, and assets attached to the land include 01 main house with horizontal size of 6.7 m, 8.7 m long, area 58.29 square meters, frame structure with local wooden columns, paneled walls, roofing, dirt floor, built in 1993, Mrs. G repaired it in 2016, 01 outhouse with width of 11.4 m, length of 21.3 m, area of 242.82 square meters, structure built with bricks, steel frame, reinforced concrete columns, tin walls, zinc-coated toll roof, ground floor, built in 5 years. 2012, 01 drilled water plant and land plant. Cancel the Certificate of Land Use Rights No. R202211 issued on November 15, 2000, of the People's Committee of District C, Ca Mau Province in the name of Mr. Nguyen Van U. Do not accept Mr. Nguyen Van U's counterclaim to force Ms. G, Ms. H, and Mr. T1 to return to Mr. U the entire disputed land area mentioned above and the house on the land. In addition, the Court of First Instance also decides on court fees, procedural costs, and the litigant's right to appeal according to the provisions of law. On April 26, 2019, the defendant, Mr. Nguyen Van U, filed an appeal against the entire first instance civil judgment mentioned above. In Civil Court of Appeal number 646, 2019, DSPT, dated December 13, 2019, the High People's Court in Ho Chi Minh City decided, do not accept the appeal of the defendant, Mr. Nguyen Van U. Uphold the civil judgment number 04/2019 at DSST, dated April 16, 2019, of the People's Court of Ca Mau Province. The Court of Appeal also decides on court fees, valuation costs, appraisal costs, and judgment enforcement obligations. In decision number 01, QDVKSDS, dated March 4, 2022, the Director of the Supreme People's Procuracy protested against Civil Appeal Judgment number 646, 2019, of DSPT, dated December 13, 2019 of the High People's Court in Ho Chi Minh City, request the Council of Judges of the Supreme People's Court to conduct a cassation trial in the direction of cancelling the above-mentioned civil judgment and cancelling the first instance civil judgment number 04/2019 at DSST, dated April 16, 2019 of the People's Court of Ca Mau Province, handing over the case file to the People's Court of Ca Mau Province for retrial in accordance with the provisions of law. At the cassation trial, the representative of the Supreme People's Procuracy proposed that the Council of Judges of the Supreme People's Court accept the appeal decision of the Procurator of the Supreme People's Procuracy. 1. The disputed land has an actual measured area of 35,180.7 square meters, belonging to land plot number 809, 810 map sheets number 10D, according to 1993 cadastral records, now land plot number 135, 136 map sheets number 10, according to the 2006 cadastral records, in Village N, Commune T, District P, Ca Mau Province originated from Mr. Nguyen Van M, died in 1998, and Mr. Nguyen Thuy B, died in 2010. The current situation on the land is 01 main house, with an area of 58.29 square meters, built in 1993, water plants, trees, and a grave site, including 03 graves. 2. Mr. M and Mr. B have 8 children including Mrs. Nguyen Thi H, Mrs. Nguyen Thi M1, Mr. Nguyen Van C, died, unknown year, Mrs. Nguyen Thi G, Mr. Nguyen Van K, died in 2016, Mr. Nguyen Van L, Ms. Nguyen Thi P, Mr. Nguyen Van U. 3. During the process of resolving the case, Ms. Nguyen Thi G said that Mr. M and his wife, Mr. B, gave her the above land in 1998. After being given the land, Ms. G has continuously managed, used it. There are repairs to the house on the land. Meanwhile, Mr. Nguyen Van U did not admit that his father and mother had made a will for Mrs. District C residents to issue land use rights certificates. 4. According to the will dated May 16, 1998, Mr. M and Mr. B gave Mrs. G a large area of land of 15 acres. Although the will does not record a specific land area, only stating 15 large plots, it does state the 4 neighbors of the land. Front borders Canal N, east, rear, borders Nguyen Van L1, north borders Lai Ting H1, west adjacent to Quoch Van M2. Thus, the land of Mrs. after Mr. M died, in the family meeting minutes dated June 15, 2004, and the will dated September 9, 2006, Mr. B expressed his will to give Mrs. G the entire area of 32,500 square meters of land, which is appropriate. In 1998, Mr. M and Mr. B, his wife and husband, made a will giving to give Mrs. G land according to the campus. 5. The will dated May 16, 1998, was made by Mr. M and Mr. B, signed by the children, including Mr. U, and certified by the local government, minutes of family agreement dated June 15, 2004. Signed by the children, not signed by Mr. U, and confirmed by the local government at the time of making the will and family meeting with the children of Mr. M and Mr. B. No one objected to the 2 giving Mrs. G the entire disputed land. They all confirmed that because Mrs. G lived with her father and mother since childhood, her father, mother and siblings agreed to let Mrs. G manage the land to worship her father and mother. Mr. U personally believes that Mr. U was given land by Mr. M and Mr. B in 1998. So on November 15, 2000, Mr. U was granted a land use right certificate by the People's Committee of District C. But Mr. U did not present it. Get evidence to prove that your parents donated the land. 6. For declaration, registration, and issuance of Certificate of Disputed Land Use Rights. Cadastral Information Provision Form Number 32, PCCTT, dated December 29, 2016 of the Land Registration Office Branch District P, shows that Mr. M registered and declared in 1993, and received a Certificate of Land Use Rights from the People's Committee of District C and G. By 2006, Ms. G registered and declared land use rights. In Official Dispatch Number 1922, UBND dated October 23, 2018, the People's Committee of District P said that the application for granting a land use rights certificate to Mr. U was lost. On the other hand, in the Minutes of Conciliation, dated February 23, 2017 of the People's Committee of Commune T, Mr. U presented that Mr. M authorized him to make a certificate of land use rights to mortgage for a loan at the bank. 7. In 1998, Mr. U did not live with his father and mother, but lived in Hamlet I, Commune T, at the same time, manage and use the land area of about 06-07 hectares. Mrs. G, Mrs. M, and Mr. L all determined that the land Mr. U used in Hamlet I belonged to Mr. M, Mr. B for Mr. U to use, including a part of Mr. Part of the 6th child to support his parents. Mr. U said that the land he used in Hamlet I was partly granted by the corporation and partly transferred, but Mr. U could not present evidence to prove it. 8. When resolving the case, the Court of First Instance and the Court of Appeal based on the content of the will, family meeting minutes, testimonies of Mr. M and Mr. B's children and the management process. Continuously using land since 1998 of Mrs. G, as well as declaring and registering the land, thereby accepting Mrs. G's lawsuit request, recognizing that Mrs. M and Mr. B have grounds. For the above reasons, decided, under Point A, Clause 2, Article 337, Clause 1, Article 343 of the 2015 Civil Procedure Code, 1. Do not accept the decision to appeal to Cassation Number 01 EQDVKSDS, dated March 4, 2022, of the Director of the Supreme People's Procuracy. 2. Uphold the Civil Appeal Judgment Number 646, the 2019 DSPT, dated December 13, 2019, of the High People's Court in Ho Chi Minh City. Contents of the law. 4. According to the will dated May 16, 1998, Mr. M and Mr. B gave Mrs. G a land area of 15 large plots, but stated the four neighbors of the land: front bordered by Canal N, east to rear, borders Nguyen Van L1, north borders Lighting H1, west borders Quoch Van M2. Thus, the land of Mrs. after Mr. M died, in the family meeting minutes dated June 15, 2004, and the will dated September 9, 2006, Mr. B expressed his will to give Mrs. G the entire area of 32,500 square meters of land, which is appropriate. In 1998, Mr. M and Mr. B, his wife and husband, made a will to give Mrs. G land according to the campus. Contents of the law. 4. According to the will dated May 16, 1998, Mr. M and Mr. B gave Mrs. G a land area of 15 large plots, but stated the four neighbors of the land: front bordered by Canal N, east to rear, borders Nguyen Van L1, north borders Lighting H1, west borders Quoch Van M2. Thus, the land of Mrs. after Mr. M died, in the family meeting minutes dated June 15, 2004, and the will dated September 9, 2006, Mr. B expressed his will to give Mrs. G the entire area of 32,500 square meters of land, which is appropriate. In 1998, Mr. M and Mr. B, his wife and husband, made a will to give Mrs. G land according to the campus. 8. When resolving the case, the Court of First Instance and the Court of Appeal based on the content of the will, family meeting minutes, testimonies of Mr. M and Mr. B's children, and the management process. Continuously using land since 1998 Mrs. G, as well as declaring and registering the land, thereby accepting Mrs. G's lawsuit request, recognizing that Mrs. M and Mr. B have grounds.